everyone. Welcome to SMC. I'm Tom Jordan, Chair of the Southwestern Michigan College Board of Trustees. It is my privilege to welcome the Supreme Court and all of our guests who have joined us for this very special event this morning. We are especially grateful for the opportunity this gives our students to experience the judicial process. I also want to thank the Pokagon Band of Potawatomi for a lovely reception last night and at their facility just across Daly Road. SMC will celebrate its 60th anniversary this year on November 3rd. Our story at SMC is one of vision, resilience, and hard work. Because of the aspirations of citizen leaders, many of whom became long-serving trustees, and the generosity of our local taxpayers, and the dedication of our faculty and staff for 6 decades, and the more than 14,000 alumni who chose SMC, the college has thrived and lifted our Roadrunner community. This event is but one more achievement, and on behalf of the entire college community, a hearty thanks to all of those who have made today possible. And there's so many that made today possible, I cannot list them all. But thank you and welcome.
Good morning, everyone. I am Carol Beeler, and I'm the Chief Judge of the Cass County Courts, and along with me is Chief Judge Michael Petoskey from the Pokagon Band of Potawatomi Indians. And we're just really excited to be here with you today. This is a community event, and we're hoping that you will see the community that exists in terms of the collaborations between our courts, between state courts, tribal courts, and this event has been planned for such a long time, and we're so excited to see all of you because our young people, it's really important to us that you're able to see the law in action, but also to learn a little bit about our different tribal courts, our state courts, and to just see how we can all work together to make our communities better, because public service can be the most rewarding life. So it's my honor now to be able to introduce you to some of my colleagues from surrounding counties who are also serving on the bench. And we're fortunate today to have judges from Cass County, from the Pokagon Band of Potawatomi Indians, from Berrien County, Van Buren County, and St. Joe County. Please welcome all of my colleagues. I'm going to turn things over to Judge Petoskey, and he's going to share some more information with you.
Welcome, everyone. Man, we've looked forward to this day for a long time. There's been a lot of planning and collaboration in the planning between the state courts and the tribal courts. One of the things that you should recognize are there are 12 federally recognized tribes in the state of Michigan. And it was about 30 years ago that then Chief Justice Michael Kavanaugh brought together tribal court judges and state court judges for the very first time. He looked at us tribal court judges and he said, we know we will learn more from you than you will learn from us. In addition, he looked at the state court judges and then us tribal court judges and said, if we work together, we are each going to be able to serve our respective constituents better than if we worked in isolation of each other. And that certainly has been true. We're in our 4th decade of this collaborative relationship, and Michigan really is at the forefront and is recognized throughout the entire United States as a leader and a model for other states and the tribes that exist within those states, of collaborating, working together, learning from each other. And this has been wonderful. We have such great friends. It is my extreme pleasure to introduce a justice of the Michigan Supreme Court. She is the daughter of the Chief Justice that I began working with over 30 years ago, Justice Michael Kavanaugh. Megan Kavanaugh is now on the bench. She's the Supreme Court, Tribal Court liaison, and she's just such a wonderful person to work with. She'd like to make a statement.
Good morning. Wonderful to see you all here. Thank you for being here. On behalf of the Michigan Supreme Court, I am honored to be able to give a land acknowledgement today. And at an educational civic engagement event like this, it's only fitting that each of you know that today the Michigan Supreme Court acknowledges that our oral argument today is being conducted in the ancestral homelands of the Pokagon Band of Potawatomi. Families of the Pokagon Band lived all along the St. Joseph River Valley from ancient times to the present. As area residents, you all know that this region contains numerous Pokagon and Potawatomi place names. Their history and place here are well known. But that history has not been all positive. Historically, our state government and institutions have been complicit in the federal government's displacement of Native people from their land, destruction of the Native family, and traumatizing of Native children. Rather than harbor justified anger and resentment, Michigan tribal members, like Chief Judge Petoskey, and other members of the Pokagon Band of Potawatomi, have extended our state courts, and the Michigan Supreme Court in particular, the grace and trust required to work in partnership to improve the lives of all of Michigan people, children and families in particular. More than 30 years ago, Chief Judge Petoskey was gracious enough to answer my father, former Chief Justice Michael Kavanaugh's request to help educate our state court judges about the sovereignty and wisdom of our tribal partners. Together, they established the Tribal State Federal Judicial Forum, and I am grateful to follow in my father's footsteps and serve as our court's liaison to that forum. I am also grateful for Chief Judge Beeler's service on and commitment to the forum. The purpose of the Michigan Tribal State Federal Judicial Forum is to create an ongoing dialogue and respond to joint and cross-jurisdictional issues among state, tribal, and federal judiciaries regarding working relationships and the interaction of state, tribal, and federal court jurisdiction in Michigan. The forum is charged with making recommendations and implementing philosophies, practices, and procedures to enhance our common responsibility to our children, our families, and our communities of sovereign nations. In exercise of its charge, the forum strives to embody the 7 grandfathers' teachings: truth, honesty, humility, wisdom, love, respect, and bravery. The Potawatomi are known as the keepers of the fire. They have worked with our court to kindle and tender a fire of positive relations between our 2 separate and distinct governments. For that, we are grateful. For all these reasons, we are proud that the Pokagon Band is a partner and a very visible part of today's events. They have welcomed us here today. We thank them by saying, Chi Miigwech.
It is with extreme pleasure that I introduce a drum from our community, Ribbontown. John, is there anything you'd like to say about what it is you might be doing, or do you want me to do it?
It's up to you.
Okay, it's an honor song to honor all of you, to honor the Michigan Supreme Court, to honor the state court judges and all of you who are here. in town for making the time to come and make this special. This is a historic event showcasing the partnership between the tribal courts and the state courts. I also would like to thank the Michigan Supreme Court for understanding the importance and the meaning of making a land acknowledgement statement.
Good morning, everyone. My name is Dan Brubaker. I'm the Chief Commissioner of the Michigan Supreme Court. Before I start, can we have another round of applause for that? I have been to a lot of Michigan Supreme Court oral arguments, and that just blew me away. So I'm the Chief Commissioner of the Michigan Supreme Court, and I'm here with another attorney from my office, Liza Moore, and we are going to provide a quick background on the court and the case in which you are about to hear oral argument. Before we begin, I'd like to tell you a little bit about the justices. There are 7 justices of the court, and the justices have 8-year terms unless they are appointed to fill a term. The Chief Justice is elected by her fellow justices. Our current Chief Justice is Justice Elizabeth Clement. Before being elected to the court, Justice Clement was the Chief Legal Counsel for the executive branch of the state government. Justice Zara is the longest-serving justice. He was appointed in 2011. He was a circuit court judge in Wayne County and a Court of Appeals judge before he became a Supreme Court justice, and he teaches at the University of Detroit Mercy Law School. Justice Viviano is next in seniority. He's from Macomb County, where he previously served as a circuit court judge. Justice Viviano serves as the court's point person on technology and electronic filing, which has significantly changed the way that courts operate. Next up is Justice Bernstein, who was first elected in 2014. Prior to being elected to the court, Justice Bernstein headed up the Public Services Division of the Sam Bernstein Law Firm, where he advocated for disability rights. Justice Kavanaugh is next. She was here earlier. I had the honor of working with her father, Justice Michael Kavanaugh, when he was on the court. Justice Kavanaugh grew up in East Lansing and joined the court in 2019 after spending many years in private practice as one of Michigan's top appellate attorneys. Justice Kavanaugh is also the Supreme Court liaison to the tribal courts. Next is Justice Welch. She took the bench in 2021. She's the only justice from Grand Rapids, which is my hometown. Before she became a justice, she practiced labor and employment law at a few large firms. She eventually opened her own private practice firm, and she also served on the East Grand Rapids Public Schools Board of Education. And then our newest justice is Justice Bolden, who was appointed by Governor Whitmer and began her term just last year. Before becoming a justice, she was a state representative in the Michigan House of Representatives, where she worked extensively on criminal justice reform and legislation to protect survivors of sexual abuse. So the state court system is kind of like a pyramid with the Supreme Court at the top. There are a lot of district and circuit courts in Michigan, and those are also known as the trial courts. From those courts, if you appeal, you go to the Michigan Court of Appeals. And the Court of Appeals has several offices throughout the state. And if you appeal from the Court of Appeals, then you come to the Supreme Court. There's just one Michigan Supreme Court, and that usually we hear oral arguments at the Hall of Justice in Lansing. Unlike the lower courts, the Supreme Court really doesn't have to take cases. Parties have to ask the court to take the case. They do that by filing what's called an application for leave to appeal. And we get about 1,400 to 1,600 applications every year. We only hear arguments in about 80 of those cases. The court is looking it is most interested in cases that have a significant impact on the people of the state of Michigan. One thing to note too, there are no juries in the appellate courts. Instead, each party is attempting, in our case in the Supreme Court, each party is attempting to persuade the court that the result of the Court of Appeals decision was either correct or incorrect. They're arguing over whether that court got it right. The appellant, who is the one who's filing the application for leave to appeal, is generally arguing that the Court of Appeals got it wrong and they want to see a different result. The appellee, on the other hand, is saying, you don't need to look at this case any further, the Court of Appeals got it right. There are no objections. As you'll see in the argument that's going to take place in just a few minutes, there are no objections. It's not like you see in trial courts where attorneys are jumping up and saying objection. Each party just gets to explain their case. On the other hand, there will be a lot of questions from the justices. The justices are going to jump in and ask them questions as they go along and make their argument. And Commissioner Liza Moore is now going to brief you kind of on the to explain the case so you have a little bit of an understanding of what's going on and what the parties are arguing.
Thank you, Dan. Good morning, everyone. We are so honored to be here today. And today, the court is going to hear the case of People versus Oslin. I'm here to share a bit of background information about that case. This case involves high school students. At the request of one of the co-defendants, the complainant met the co-defendants behind a building, and other students had gathered there. Two of the co-defendants began striking the complainant with their hands and feet. Meanwhile, the defendant took a short video of this incident. That video was forwarded to a co-defendant, it was circulated online, and it was sent to the complainant. As a result of this incident, defendant was charged with assault with intent to commit great bodily harm less than murder under an aiding and abetting theory, and as an adult under what is called the automatic waiver statute, MCL 764.1F. That statute is important to today's argument. The district court bound defendant over to trial at circuit court, and the district court judge said that co-defendant's shoes constituted dangerous weapons for the purpose of that automatic waiver statute. The circuit court denied defendant's motions to quash and to dismiss, and after a remand, the Court of Appeals affirmed. The Michigan Supreme Court granted leave to appeal, and that's what we're going to hear today, and identified two issues. One, whether shoes constitute dangerous weapons for the purposes of the automatic waiver statute, and two, even if shoes can constitute dangerous weapons, whether defendant's motion to quash should have been granted because there was no evidence he was armed with a dangerous weapon as required by the statute. Let's break down those two issues a bit further. This is a case involving juvenile defendants. Generally, the family division has exclusive jurisdiction over cases involving juvenile defendants. In what's called a traditional waiver case, the family division may waive jurisdiction if a juvenile is at least 14 years of age and is charged with an act that would be a felony if committed by an adult after a prosecutor files a motion and there's a hearing. But those special procedures don't apply in what's called an automatic waiver case. In those cases where a juvenile is accused of a specified juvenile violation, the prosecutor may waive and directly file in circuit court for proceedings as an adult. So let's break down that automatic waiver statute a bit more. It applies to a list of specified juvenile violations, and that includes assault with intent to commit great bodily harm less than murder, which is the charge at issue in the case here today, if the juvenile is armed with a dangerous weapon. So what does a dangerous weapon mean? The statute defines a dangerous weapon as including a firearm, knives, and key here today, an object that is likely to cause death or bodily injury when used as a weapon, and that is used as a weapon or carried or possessed for use as a weapon. The Court of Appeals said there weren't any cases that explained what dangerous weapon means within the context of that automatic waiver statute. But the court said that there were cases that explain what dangerous weapon meant in the context of a different statute, felonious assault, and that in those felonious assault cases, footwear had been considered a dangerous weapon. So with those principles in mind, let's go back to what's happening in this case. As I mentioned a moment ago, a defendant was charged with assault with intent to commit great bodily harm less than murder under an aiding and abetting theory, and as an adult under that automatic waiver statute. The district court bound defendant over for trial in circuit court. The district court judge said this case was right on the borderline, but said that co-defendant's shoes constituted dangerous weapons for the purposes of the automatic waiver statute, and relied on those felonious assault cases to make that decision. In circuit court, defendant moved to quash the bind over and to dismiss the charges, saying this shouldn't be an automatic waiver case. The circuit court denied his motions. Defendant then asked the Court of Appeals to hear his case, and initially the Court of Appeals denied leave. He then asked the Supreme Court to hear his case, and instead of granting leave to appeal at that time, the Supreme Court remanded, which is another way of saying sent back, the case to the Court of Appeals for consideration as on leave granted. On remand, the Court of Appeals affirmed. The Court of Appeals majority said that the term dangerous weapon should have the same meaning in both the felonious assault statute as it does in the automatic waiver statute. One of the Court of Appeals judges dissented. And that brings us to where we are today. Defendant filed what's called an application for leave to appeal to the Michigan Supreme Court, and that was granted. The court identified two issues for the parties, which I mentioned a moment ago. One, whether shoes constitute a dangerous weapon for the purposes of that automatic waiver statute, and 2, even if shoes do constitute dangerous weapons, whether defendant's motion to quash should have been granted because there was no evidence he was armed with a dangerous weapon as required by the statute. That's what the court's going to hear right now. Defendant is the appellant. This is his appeal. The prosecutor is the appellee. Students, as you're watching this argument here today, think about how this decision is going to affect the people involved in this case and how the decision might affect other juvenile cases across the state. I hope that you have many questions and that you think of more questions as you're watching the oral argument. There's going to be a time to ask those questions after the argument has concluded, so hang on to your questions until then. With that, thank you all very much, and let's proceed with the argument.
Hear ye. The Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning. Welcome to the 29th Court Community Connections Program. Before I call today's case, a special thank you to our hosts, to the students, and to the educators who have joined us today. We have students from Andrews University, Brandywine Schools, Buchanan High School, Calvary Bible Academy, Casablanca Schools, Catholic Schoolhouse Homeschool Co-op, Dowagiac High School, Marcellus Vollinia High School, Niles Public Schools, Our Lady of the Lake School, and Southwestern Michigan College. My colleagues and I very much appreciate the opportunity to be here in Cass County and the Pokagon Band of Potawatomi with you, and to highlight our commitment to community engagement, collaboration, and building trust. A special thank you to Southwestern Michigan College Chairman Tom Jordan, President Dr. Joe, and the entire staff, faculty, and student body. Gratitude is also extended to the Pokagon Band of Potawatomi, including Chairwoman Rebecca Richards, Chief Judge Michael Petoskey, and the tribal courts and staff. Thank you as well to the judges and staff of the Cass County Courts, especially Chief Judge Carol Peeler. And thank you to our Michigan Supreme Court Commissioner's Office for briefing the audience regarding the case. The court also appreciates the local attorneys who have volunteered their time to be here today. We are very much dependent on the local bench and bar for their support and cooperation. Given the extraordinary extent of this year's collaboration, this event has had more moving parts than any previous court community connections. Many, many people worked together to make this event a reality, and I thank everyone who has contributed. Finally, we are also grateful to the Michigan State Police, Cass County Sheriff's Office, Pokagon Band of Potawatomi Tribal Police Department, Dowagiac Police Department, and our Michigan Supreme Court Security. Welcome to everyone watching the live stream. And while you're online, make sure to follow the court on Facebook, Instagram, and LinkedIn. A couple of housekeeping items. First, with the exception of the media and the professional photographers, no one should take photos once oral arguments begin. There will be plenty of opportunity for photos during the reception. Second, if you have not already done so, please turn off all cell phones for the remainder of the proceedings. Following oral argument, please remain in the courtroom for the debriefing with counsel for the parties. Today we have Michigan Supreme Court Chief Commissioner Daniel C. Brubaker as our moderator. Oral argument is a key part of the appellate decision-making process because the issues raised and questions answered help determine the outcome and may affect the outcome of future cases that lower courts are bound to follow. By the time of oral argument, the justices are very familiar with the case. We've read the parties' briefs and the applicable lower court record, and we've studied the legal issues. The questions we ask during oral argument and counsel's answers to those questions do help us reach a decision, but more importantly, they can help us, if we decide to render an opinion in the case, to
craft an accurate and clear statement of the law. Like us, you have already been briefed about this case. You know what the issues are. You've come to today's hearing with questions you would ask if you were a justice. And when the court issues its decision, you will get to analyze our ruling and decide whether you agree or would have done things differently. Our goal today is to leave everyone watching better informed about the rule of law and its role in our constitutional republic. My hope is that as a citizen of your community, you'll remember this experience and maybe even be inspired to learn more about the law and potential careers in our justice system. Now it's my job to call the case People of Michigan versus Evan Andrew Osland. Good morning. You may reserve time for rebuttal, but we ask that you keep track of that.
Thank you.
And you may begin when you're ready.
Yes, I would like to reserve 3 minutes for rebuttal, and I'm not going to ask that the court refrain from questions at the beginning of my statement and argument. So I want to start by saying this looks like a case about shoes. I am Christina Dunn for Evan Osland, and I am also from the Livingston County Public Defender's Office. This is a case that looks like it's about shoes, but I really believe it's about something much more important. It's about judicial and legislative gatekeeping, and about how the trial courts, and in this case the district court and circuit court in Livingston County, are asked to evaluate evidence. They have a need for guidance because what happened in this case shows that there's more than a loophole, which is what Judge Hood said in his dissenting opinion, given this automatic waiver statute. It's really a loose thread, and if we follow that thread, we see that there are lots of issues within the statute that have come to a head because of this case. Why are we charging these children as adults anyway? Why did the prosecutor choose to use an automatic waiver method to bring these defendants and my client into the adult court? There are other options. They could have used a designation statute trial. They could have used a traditional waiver statute proceeding. And those two proceedings provide safeguards that are not provided in an automatic waiver setting. Designation cases go to trial in the family court, and there is an option at the end of the trial for a judge to determine that the defendant should be sentenced as an adult or a juvenile. Then the judge can consider all the things about that person in fashioning a proper sentence. In a traditional waiver case, the judges would decide that my client, or any client, any defendant, had something in their criminal history that allowed for the waiver to an adult court. In this case, my client had no prior contacts with the criminal justice system. A traditional waiver would have failed because there would have been no reason to bind him to an adult court. There was nothing in his criminal history that would have allowed such a waiver. Traditional waiver also provides a special protection for defendants, juvenile defendants, in that
Let's switch gears over
Yeah.
to the questions that we asked and
absolutely.
whether shoes can constitute dangerous weapons.
So shoes, I think that a common sense analysis would tell us that shoes could be a dangerous weapon. I'm going to concede that. In the right context, I think that a shoe, depending on the type of shoe and how it is used, could easily be a weapon, a dangerous weapon. It could cause
I
someone...
think you just cut out a lot of questions that we might have to list off all the different types of shoes, right?
Right. I could go through a long list.
Right.
We have steel-toed boots. We have stiletto heels. We have golf shoes with cleats. There's a lot of hypotheticals we could think of. But in this case, we don't have that kind of shoe or the use of a shoe. And again, the statute's quite clear. It says use something as a dangerous weapon or carry it as a dangerous weapon. I mean, presumptively, the legislature, when they created this exception to assault with intent to do great bodily harm within the statute, they were onto something. They were thinking about something. I don't think they assumed that assailants would be barefoot, right? I think that they assumed that everyone would be dressed, wearing shoes. They're looking for something more.
Could that something more be an individual that is intending to cause harm to someone and intentionally puts on a pair of steel-toed boots with the goal of causing injury by kicking someone wearing a boot that is not something normal to wear to, to school.
That's exactly the type of situation I would envision, that we could say a shoe was used as a dangerous weapon. We don't have those facts here. We also have this funny situation where my client wasn't the assailant. He was, in theory, charged under an aiding and abetting theory, although I think that that's a very thorny path to go down. If his co-defendants had been adults, they'd been 18, they wouldn't have needed to have, no one would have been able to find that they needed, or I'll step back, the court need not find that they had weapons. Assault with intent to do great bodily harm charged as an adult crime does not require a weapon. So if they had a joint preliminary exam, one juvenile, 2 adults, no weapon would need to be found for those adults. But in order to gain personal jurisdiction over my client, which is what we're talking about, they would have had to show that my client had a weapon.
So counsel, just fleshing that out a bit more, I think CDAM did a pretty thorough job in its amicus brief on that issue, sort of this aiding and abetting and transferring elements over to someone, recording the encounter and not actually directly part of the encounter. Of course, under normal aiding and abetting statutes, we let that happen. Here, it's a bit different, and why is it different?
Well, in this case, what the court had, it had a dual purpose at this preliminary exam, right? It wasn't just to find enough evidence to bind the case over. It was to find personal jurisdiction against these defendants. It's like a dual purpose preliminary exam. And because of that, we have a problem, because that means that each of those individuals have to show that there was some weapon used to gain personal jurisdiction for each individual. And my client has to be looked at as an individual, as a juvenile defendant, not as part of the, I think it really kind of confuses the issue in a way that's not appropriate to say that there's an aiding and abetting theory. And even then, if we talk about aiding and abetting, my client would have had to share the specific intent of the actual assailants, that they were intending to use shoes as a dangerous weapon. There's nothing that shows that he shared that specific intent. Because this is a specific intent crime that they've charged the way it's been charged, which again turns everything we know about assault with intent to do great bodily harm on its head. Right? Why did the legislature make this exception and require a weapon for assault with intent to do great bodily harm for automatic waiver? What were they thinking? That's my question to me. Why did they put that in there? They were worried about something. They were worried about this case, because they wanted only those most serious cases to be bound over automatically into the adult court. They don't even allow automatic waiver for felonious assault. Right? Felonious assault is not a specified offense. So again, I believe that some of the arguments here are really not focusing on what we're here for, which is a question of personal jurisdiction in the circuit court over my client. In the Court of Appeals, the majority opinion spends a great deal of time talking about impera materia. In other words, because there are other cases that say that shoes could be weapons, that the district court didn't err because shoes could be weapons. However, all the other cases they cite are adult cases. None of them are juvenile. And they're old cases, pretty old.
What does it matter that they were adult cases and not juvenile? I mean, a shoe, defining a shoe as a dangerous weapon, that definition shouldn't change depending on whether it's an adult or a juvenile.
Well, I think it does because of the way the statute is written. The automatic waiver statute is written very specifically. It enumerates what kind of weapons are allowed. We don't normally do that. The felonious assault statute doesn't do that. Assault with intent to great bodily harm doesn't do that because it doesn't need a weapon. Weapons are very specifically described, and they include a statement that it must be carried and used as a weapon. That's different than any other case law, and we're really relying on a body of case law to define when a shoe becomes a weapon. In this case, we have a statutory interpretation that we should rely on, not case law that's not related to juvenile waiver.
So it's not the definition of dangerous weapon and whether or not a shoe fits into that or not. It's the other language in the statute that describes describes the act.
I believe that that is what the legislature intended, and that's why they put that language in there. Carried and used as a dangerous weapon, not just shoes you wear every day to school.
Did the district court judge ever make a factual finding on that second point or series of points in the statute?
No, he really didn't go into detail about any of these issues. He did say that shoes were worn, there was kicking. I mean, everyone's seen the video, so we know that there was kicking, but he didn't really go any further. I think, again, he didn't have the tools he needed to say, well, wait a minute. First of all, your client, Evan Osland, wasn't an assailant, and he didn't use a weapon. And he also didn't understand or didn't have the tools to declare that shoes just worn as footwear can't be used and carried as a dangerous weapon, because there was no direction.
The first point's a factual point, so are you asking us to remand it to the district court so that the judge can make a finding on that point?
No, I'm asking this court to find that given the evidence, just like if I move to quash in the circuit court, that this court can evaluate the evidence itself. And the motion to quash is evaluated de novo. My motion here, or my application here, could also be evaluated de novo. This court has the tools to make that determination. If the court saw fit to remand it and ask Judge Bain to decide if this has been carried as and used as a dangerous weapon, that's the argument I made to him, but he didn't evaluate that.
On the last point, which I view as a legal point, we asked it as a factual question in our order, but the point about whether the juvenile is armed with a dangerous weapon, I think there's a legal question there as to whether the aiding and abetting statute can fulfill that requirement.
I agree.
You started to argue that here today. Was that issue ever argued to the lower courts?
Well, it was argued by the prosecutor that that was their theory here, is that my client aided and abetted this offense and that the offense was committed with shoes. So yes.
Do you ever respond by saying that under the aiding and abetting statute doesn't apply to satisfy the waiver statute?
I did. I said that this statute has not been satisfied because there has not been a showing that my client used shoes as a weapon, carried them as a weapon, as a dangerous weapon. So there's very slim legislative history here. I think we have to rely on the statute itself and its language. I don't think that there's much we can point to show what the legislature was thinking. I do think it's instructive that they also included home invasion as one of these kind of carved out specialty offenses that could be automatically waived only if there's a weapon.
The co-defendants pled guilty, is that right?
Well, the co-defendants were bound over just like my client. You know, and this is a procedural point that I don't know that matters too much, but I think it's important to think about. My client is the only one of the three who is represented by appointed counsel at a public defender's office. So he's the only one who didn't have to pay for an attorney to file appeals or to pay filing costs in the appellate courts. The other defendants were somewhat in a bind. They were offered felonious assault and assault with intent to do great bodily harm to plead guilty under HIDA, which they did. And
how does the fact that they pled guilty, does it bear on this case at all? Does it bear on the prosecutors, what the prosecutor has to show in this case?
It does
against your
not,
client?
but it shows that if they had appealed, they would be joined here, I believe, and they'd be arguing the same points that I am, that they were not armed with a dangerous weapon and carried a dangerous weapon, shoes in this case. They too could make that argument, I believe.
Counselor, I actually was going to ask the prosecutor as well this question. I'm interested about, so they were eligible for HIDA? I thought HIDA only applied if you're 18 to 26 years old.
Correct, but that's what the prosecutor offered and what they took.
Okay.
They both failed on that probation.
Yeah, I mean, because normally juveniles are in the juvenile system.
Correct.
And then adults who are, emerging adults are in the HIDA system. Okay, thank you.
So that's troubling to me, that if my client had to hire an attorney, didn't qualify as an indigent defendant, he might have been in the same position. So here we have a weird, disparate result that these young men, people plead guilty for all sorts of reasons. Felonious assault isn't even one of the enumerated specified offenses, but I'm not sure that's really a lesser included offense. There's been a lot of discussion about pleas that are not based on the facts of the case. I would say this is one of those situations. The plea was not necessarily based on the facts of the case, but it was expedient for those defendants.
But if they, in their plea hearing, if they under oath said that they possessed and used a dangerous weapon, would that have a bearing on your client's case?
No,
Why not?
not in this case, because my client there was no personal jurisdiction in the circuit court over my client because he did not possess or use or carry a dangerous weapon.
Did they so testify? Are you aware?
I was not at their plea hearing, and I have not reviewed the plea transcript. I don't even know, I have no idea what was said on that record. I do not. I just know what the court docket says about their case.
Your position is consistent with CDAM, that when the statute refers to the juvenile, it means your client.
Correct.
If we accept that interpretation of the statute, would there ever be any instance where there could be an aiding and abetting under these circumstances?
I don't see why not. I mean, I think we can,
Or if you're actually holding the dangerous weapon, how are you aiding and abetting?
well, I would say it'd have to be something more. It'd have to actually be an aiding and abetting kind of fact pattern where there was encouragement. My client brought the shoes to be worn. My client suggested shoes be worn. Something of that nature, which clearly didn't happen in this case. But I don't know how well, I mean, again, aiding and abetting we often see with felonious assault, someone provided a gun. But we don't have those facts in this case. And again, it concerns me that when someone like my client goes to the district court, because it's not even a petition, it's just a straight up complaint filed, alleging that he used a dangerous weapon. He's in the district court. He's bound over for trial. He doesn't even have a right to appeal, right? Look at all the convoluted ways we finally got to today. I had to move to quash, move to dismiss. I had to appeal to the Court of Appeals, appeal to this court, go back to the Court of Appeals, come back to this court. He didn't have an automatic right to appeal. Just like if you were traditionally waived, you would have an automatic right to appeal that decision. He didn't even have that. Why are we not protecting those children who are charged with the most serious crimes like we do defendants who are children who are charged with less serious felonies, who go through a traditional waiver procedure? Why? I think that is the fatal flaw in the statute. If my client had gone to trial, had chosen to in this case, the prosecutor would not have had to prove that he used a weapon, right? It's assault with intent to do great bodily harm does not require that. But again, it just creates this weird conundrum. What do we do with children in this position? They're charged as adults with using a dangerous weapon, but they don't actually have to prove that at the trial court. He shouldn't be in the adult court. He shouldn't be in the circuit court. This case was improperly bound over. The motion to quash was improperly denied. You know, I practice in the trial court every day. Judges bind things over on a probable cause standard. That is much less than what's required at trial. I can foresee, and I'm sure it's happened, people bound over as adults on first-degree murder who are only convicted of involuntary manslaughter, which is not a specified offense. How can that be right? I'm going to reserve the rest of my time for rebuttal. Thank you.
William Warden, Assistant Prosecutor for the People. The district court was unclear how much discretion it had to make a factual determination on whether the shoes were dangerous weapons. The district court did not make a factual finding in this case whether the shoes were used as dangerous weapons. We request a remand for the district court to reevaluate its decision to find whether there was probable cause that the shoe was used as a dangerous weapon. The record of the prelim shows the judge saying, I don't think I have a choice under the circumstances but to bind over on all three. Then he cited People v. Hale and said a shoe can be a weapon if a defendant intended to use it as a weapon. We have the videotape. I'm stuck with shoe. I am bound by the previous case law. There's no factual finding there that these co-defendants used their shoes as dangerous weapons. And I would also submit that this issue has evolved on appeal from the prelim to the motion to quash, to the Court of Appeals, and now. And with the amicus brief that's been filed, we have additional issues regarding the constitutionality of the statute and what the use of the word "the" means in front of defendant. And all of these issues should be addressed by the lower courts. So that's the basis of our request for the remand. I would be happy to answer any questions the court may have about any of the issues, the aiding and abetting. I think counsel acknowledged shoes can be dangerous weapons, but were they used as dangerous weapons in this case? And that the judge should have decided before he bound over that there was probable cause.
Why is that a preferred or the right remedy as opposed to just saying, as counsel has urged, that the motion to quash should have been granted? And as Judge Hood also found in the Court of Appeals.
Well, if you look at the transcript of the motion to quash, I think it's on page 5. The circuit judge said, I haven't even watched the video. And so that was really important to making that decision. Counsel said, you don't need to watch it. The best evidence is the testimony of the victim who said he felt feet and hands. Because he said nothing about shoes being used in the attack, her position was that the court could, grant the motion to quash on that basis.
But now we have seen the video. We have, as counsel suggested, all the tools that we need to decide that as a matter of finality. Why should we not? Why do you urge us not to do that?
There have been more issues introduced. There have been issues regarding the aiding and abetting statute and how that is supposed to work in pairing materia with the statute involving the automatic waiver, and whether it applies in this circumstances. Now, we can all think of circumstances where 3 juveniles are involved in a beating. Maybe one of them provides baseball bats to his co-defendants, but he doesn't swing a bat himself. He just watches, or he videotapes it. I mean, under that interpretation of the statute, can we charge him as an adult for an adult crime? That's the question. If you can show that that would be an absurd result, that the statutes, the aiding and abetting statute, and also the automatic waiver statute, if you can't reconcile them based on their interpretation, that's an absurd result. And they should be harmonized. I mean, the legislature is charged with knowledge of all this, so that when they formulate the law, they know about what constitutes a dangerous weapon. They know about aiding and abetting, and the distinction.
But counsel, in your example, I mean, I think everyone would agree that a baseball bat probably is a dangerous weapon in that context. Here, we have sort of this question if shoes can even be a dangerous weapon, and then adding a layer on and then sort of transferring that over to the alleged aider and abetter. I mean, I thought CDAM did a pretty good job outlining why that's problematic.
And we haven't had an opportunity to respond. The parties have not briefed those issues that were introduced by CDAM. So that's another reason for a remand in this case.
Okay, so let's just go back to issue 1, the shoes. Why can't we, to Justice Kavanaugh's comment, we have a video, we have a motion to quash, which was not granted. I mean, how many times do we have to keep going up and down? Why can't we just resolve that issue?
Well, that may be how the court does resolve it. I'm not saying that the court lacks the authority to do that. However, generally, the lower courts are given an opportunity to address the issues that are raised on appeal if they haven't already done so. And where the circuit judge never even viewed the video and yet denied the motion to quash at the urging of counsel because it wasn't necessary, that really doesn't give the prosecution the state.
But, okay, let's assume we remand. So it sounds like the remand, I presume, your position will be you are still arguing the shoes are a dangerous weapon. Is that, I have to assume that's what you'd be arguing, otherwise what are we remanding?
When it goes back to district court, the district court judge would have to make that finding that the shoes, as used in this case, were dangerous weapons. And if you watch that video and you slow it down to like 1/4 speed, you're going to see exactly what kind of footwear was used to kick the victim in the head, and you're also going to see what the other co-defendant did with a kick to the
So is
upper-
any kick with a shoe on, is a shoe a dangerous weapon?
Well, again, the best evidence of whether it's a dangerous weapon is the injury, and in this case, the victim had a concussion. So that's good evidence that the shoe was used as a dangerous weapon. Now, granted, there were multiple blows to the head, which are shown in the video. And the judge is going to have to look at that and say, okay, the shoes were used as a dangerous weapon, probable cause, and I bind over on that basis. And these additional issues that have been raised on appeal can also be addressed.
What about, though, the fact that if I were to agree with your position, then a juvenile in this situation wearing shoes in a fight basically has less rights than an adult on, you know, the assault with intent to cause great bodily harm. Because that issue, that they never get to present that to anybody. It gets bound over and then they get prosecuted for the, you know, the crime. But obviously, if an adult were in court fighting whether shoes were a dangerous weapon or not, that would actually get to go to the jury.
Well, I think that can be remedied with a verdict form, and the jury would have to find that the defendant was guilty of assault GBH with a dangerous weapon. And if he's not, if they find that he's guilty of assault GBH without a dangerous weapon, then he's sentenced as a juvenile.
On what basis would that go to the jury in that form? Because assault with intent to commit great bodily harm does not require use of a weapon. It's only the jurisdictional original determination. So what basis? I mean, I understand your point of saying, well, we could ask the jury that, but on what basis?
Well, it's an element, and the jury should be apprised of all the elements. It's an element that the prosecution would have to prove at trial. It should be on the verdict form. And if it's on the verdict form and that's their finding, then the conviction as an adult could stand.
It's an element of the crime of assault with intent to commit great bodily harm?
When a juvenile is involved, it's in the statute.
But after already bound over, after that determination is made, does it remain an element? Or is it only part of the initial jurisdictional determination?
It's our position that it would remain an element.
It would remain.
We would have to prove that at trial.
And if that's so, that would address the constitutional concern.
And that would also address the apprendi, yes, because then the judge could sentence the individual not on the basis of facts not found by the jury, but if the jury found that as a fact.
What's your best authority or case law that says that is in fact how that works? That the jury becomes instructed on elements of the jurisdictional waiver provisions when they eventually go to trial. I mean, has there been a case that says that is in fact how it works?
I'm not aware of one, Your
Okay.
Honor.
So, counsel, under your theory or argument, it sounds to me every fight that juveniles have, as long as they're wearing shoes, could land in adult court. I mean, I'll be honest, it's hard to fathom that's what was intended when they created the juvenile system, because the juvenile system's filled with a lot of kids who get in fights.
And this is the only case in Livingston County that's ever been charged this way. It would depend on the type of shoe, of course, and it would depend on how the shoe had been used, whether it was used as a dangerous weapon.
So
and whether
in this case, what is special about the type of shoe, and when you say how it's used, so any kicking? So two parts. What shoe gets us there, and then does it have to be any type of kicking?
No, a light tap on the shins isn't going to qualify, but a case where there's a blow to the head delivered with a shod foot that may have created a concussion would be such a case.
And then what type of shoe, in this case, is what is getting us to this point?
Well, I go back to what I've already said. The best evidence is the injury that's created. And
But that's not what you just said. What you just said was the type of shoe that was used in this case.
well, if I'll let the record speak for itself, Your Honor, but what I meant to say was that if there is an injury of such a serious nature and it's caused by footwear that can be described as a dangerous weapon, and it's used as a dangerous weapon, and it's a specific intent crime, so it couldn't be something incidental. I agree with counsel for the defendant that if you are going to single out an individual for this type of assault, you might think about the type of footwear you're going to be wearing if you intend to kick him. But all of those.
So is there an acceptable type of footwear that would not qualify as a dangerous weapon?
There could be, yes.
Help me think of an example.
Well, Judge Hood in his dissent said, I think there was a subheading that said, flip-flop is not a dangerous weapon. But there are different kinds of footwear that aren't flip-flops. There's athletic slides, there's other types of things that young people wear, which, depending on how it's used, and I think if you slow down the video, you can see what's being used. The other co-defendant, the district judge couldn't really tell what type of footwear he was wearing. He also kicked the victim.
Is that the, because I've watched the video, is that the one where the shoes fly off? So they maybe are more of a flip-flop or slide, like a slide on shoe?
It appeared to me that the co-defendant who kicked the victim in the head was wearing some kind of athletic slide. And I guess it's as a matter of law, I suppose this court could decide that something like that is not a dangerous weapon. May never be a dangerous weapon, but that's, what is a dangerous weapon if it's used in a dangerous manner? A butter knife can be a dangerous weapon. There's even a case that says a dog can be a dangerous weapon. So that, I mean, it's a question of fact. The district court kind of didn't really, he relinquished his role in this process. This court could deliver an opinion which reminds the district courts of their duty to find probable cause on every element, and also remind prosecutors, you have to present that evidence. I hope I've answered your question.
Again, counsel, I think what it goes back to is just the concern that this could be overbroad. And I think it goes to Justice Welch's question, which is any fight where the people are wearing shoes could result in these type of charges. And I guess that's a little bit of a concern.
And I understand that concern, and if it's overbroad, then it may be unconstitutional. If it's unconstitutional, as CEDAM wrote in their brief, we should be given the opportunity to brief that before this court renders a decision.
Does it matter if the person, let's say, had taken the shoe off and then began, let's say, assaulting a person versus leaving the shoe on and just using it as an extension of the actual body?
And that's a good question, Justice Bernstein. As I watched the video at 1/4 speed, it appeared to me that when the white footwear flew off, that defendant picked it up and that he struck the victim on the head with it before he walked away. Striking someone with a shoe, depending on the shoe, of course, could constitute assault with intent to do great bodily harm.
Because that you're actually taking the it's not on your foot. You're actually taking the shoe and then you're using it specifically in a weapon-type situation.
Yeah, that's probably even a better argument than if you're actually just kicking someone when they're down on the ground. Particularly if the number of kicks are limited. I counted only 2 in this case. So, I mean, those are
Counted
things
2
that.
kicks? I'm sorry, you counted 2 kicks?
I counted 2 kicks. And yesterday I talked to defense counsel. She thought there were a couple maybe as well. So, I mean, it's a close issue. The district court acknowledged that.
You had indicated that this is the first time this county has used this for waiver. Can you explain what the rationale was in this case with, I'm thinking of the aider and abetter piece here, and especially after what you just said with that there were only 2 kicks.
Yeah, well, this victim, he was a special needs student. He was at a new school. They had just started the fall semester. He was trying to make friends. He thought these boys wanted to be his friends. They invited him to the skate park, and it was totally unprovoked. He suffered a blackout at the time, concussion, nausea, blurred vision, couldn't read the blackboard. His grades dropped in school. He had to leave his job at McDonald's to work on his grades. He had PTSD, just imagining what it would be like to go to court and face the co-defendants in this case. So it was kind of a severe case, and we had the video, which showed just how severe that beating was. So that went into the decision to charge these 3 co-defendants as adults. Any further questions?
I don't see any. Thank you very much.
Thank you.
So again, I just heard the prosecutor say that the district court relinquished his role here. This is my point. This is all I'm arguing, is that the district court and then Judge Hattie, the chief judge, and the circuit court by extension did relinquish their role. They did not appreciate that this was a dual-purpose preliminary exam, that my client was differently situated than the 2 assailants, and that the district court was required to find personal jurisdiction and to bind the case over as an adult felony.
But
And that-
counsel, this was a particularly cruel crime, wasn't it?
Well, I don't want to diminish what happened, and I know the courts watched the video, but I will tell you that my client is a special needs student also. He also was the beginning of school. He was also asked to take a video by people he barely knew, and he did that. There's no excuse for that. He sent it out to other people. No excuse for that. But to say that the victim blacked out, that's not exactly right. He said he saw some darkness. He actually got on the bus and went home, didn't do anything, told his mother what happened. She said you should report it. The next day they went to the emergency room or urgent care, I forget which, and they said he had a mild concussion. Again, he had been suffering from disabilities before this occurred and had had a lot of struggles in school and at work and with his peers. I'm sure this exacerbated that. But to say that this was a particularly egregious situation, that's not what the record supports.
The people essentially say the district judge didn't understand its role. We should vacate and remand to the district court, tell them they have discretion, and do over. What's your position on that?
I think the prosecutor at the time in the trial court, Ms. Akins, and I told the district court exactly what we thought the law was, and he did have the ability. He just relinquished his role. He did not want to be the one to say, I'm shutting this down.
Was that in support of the prosecutor's position or in opposition to it? That you told him and the judge still didn't understand that there was discretion here. Should we send it back and tell the judge, there is discretion, I'll make a ruling exercising that
Well,
discretion?
when I say relinquish his role, I don't mean that Judge Bain didn't realize he had discretion. He does preliminary exams all the time. He understood that, but I stand by my original position that the remand is not necessary, that all the evidence is before this court, was before the district court, was before Judge Hattie, and we already know what should have happened.
Thank you.
Thank you.
Thank you. Thank you both. The case will be submitted, and the court is adjourned.
Okay. Hello again. We're going to go ahead and get started. And at first I want to say that arguing before any court can be a little nerve-wracking, and arguing before the Michigan Supreme Court with the 7 justices can be particularly stressful. But arguing before the Michigan Supreme Court with in front of you with a bunch of students and judges at your back is kind of above and beyond the call of duty. So please give a round of applause to our attorneys here. I do want to thank everyone in the audience for being here and for the justices for coming here today. A lot of us came yesterday and we had an amazing tour and a wonderful dinner. It's just been a great experience here. So I'd like to thank everyone who took part in putting this together, including the people here from Cass County and the people at the Michigan Supreme Court. You're probably wondering, like, what's going to happen next? And I will say one of the things I really like about my job as the Chief Commissioner is that usually after the oral arguments, I'm back there with the justices and I get to hear them discuss the case, and I know what they're going to do with it. At this point, I have no clue what they're going to do with this case, but what's happening now is the justices are meeting. They're going to talk about the briefs that they've received. They're going to talk about the oral argument, the questions that were asked, the answers that were given. And they're going to pick each other's brains about what they think should happen. They have a whole range of options available to them at this point. They could do what's called deny leave to appeal and just leave the Court of Appeals decision in place. They could reverse the Court of Appeals and say they got it wrong. They could affirm the Court of Appeals and put their own stamp on it, say they got it right. They could remand the case to a lower court for additional factual or legal findings. And they could even do what's called grant leave to appeal, and they might say, like, we actually need more argument and more briefing on this case, so they could grant leave to appeal and we could kind of do this all over again. I don't know what they're going to do, but I do know this. All of the justices have given a lot of time and attention to looking at this case and thinking about it, and they are back there now having a civil discussion that includes listening to each other, carefully and thoughtfully considering each person's point of view. And that's one thing I love about the court and one thing that makes me proud to work for the court. So we now have about 25 minutes for questions before we head to the, I think there's going to be pictures that are going to be taken here on the stage. I do have some questions if the room goes silent, but I'm really hoping I don't have to use my questions. My hope is that all of you who witnessed this have a lot of questions. Those of us who took part in today's event are really interested in what you think and what you have to say about today's oral argument. So please do not be shy. If you have a question, get your hand up. I think there's microphones that people will bring you a microphone, and just go ahead and ask the question. So with that, I think if anyone has a question, please raise your hand and a volunteer will give you a microphone.
If they rule that shoes can be a weapon in this case, would that lead to other clothing parts like belts or shirts or pants to be it? Because as we've seen in media and stuff, and in the past, belts and that have been used by serious criminals to harm people.
You want me to answer it right now?
I'm sorry, could you repeat the question?
Could other articles of clothing be considered a dangerous weapon in future cases after this?
Well, I think that it would depend on how that was used. Let's say you had like a chain necklace and you loop it over somebody's head and you start strangling them. Obviously, that article of clothing is being used as a weapon. So it would depend on the facts in the case. And this particular case, I think that the district court, he should have made that factual finding that the shoes were actually used as a dangerous weapon. And so maybe my esteemed colleague would have a different view.
Well, this case is fact specific, so the court in this case will probably not rule on other articles of clothing. It would probably make a decision based on what happened in this particular case. Again, the statute, and we all stated the statute, it had the item, which is a pair of shoes in this case, or flip-flops, had to be used as and carried as a dangerous weapon.
Hi. Goodness gracious, that's loud. In a similar vein to her, with the shoe, when you wear it and you kick somebody, it's gonna hurt. But if you take off the shoe and you kick somebody, it's still gonna hurt. So if you were to have like a fist and you were to throw it at somebody and give them a concussion, whether or not you're wearing like a cotton glove or something, you're still gonna give that person like a concussion. So would the glove or the shoe in this case, in both cases, without or with the article, still constitutes the same injury? How would that be considered a dangerous weapon? Another interesting fact is that when we go to boxing, when they're throwing punches at each other, the boxing glove is not a weapon. It's used to both protect the hand and the other person's face. Bare knuckle boxing is much, much more dangerous.
Right. And I think that in a circumstance where a person gets in a fight and they punch another person and they suffer an injury, a serious injury like a concussion, that would not qualify under the juvenile automatic waiver statute. So, like counsel said, this case is somewhat fact specific, and maybe she'd like to elaborate on that.
Right, so we are arguing that the legislature did not want fist fights or unarmed combat to be automatically waived, that juveniles should not be in adult court if there's just a fist fight. So to your point, an adult could be convicted of assault with intent to do great bodily harm using just their fist, and I believe that there's a case on that point where a person was particularly adept at hand-to-hand combat, but for a juvenile to be convicted and waived to the adult court, there has to be the use of and carrying of a weapon.
The use of the co-defendant actions to charge the defendant for just recording, and he didn't even know how bad the co-defendants were going to beat the boy so bad to equal him to go to the hospital with bad conditions.
I'm not sure I understood the question. I had an appointment yesterday with an ear doctor, and he tells me I need hearing aids. Maybe if you could repeat it in a very loud voice.
How can you charge the co-defendant for the actions that the defendant had done to the boy for just recording, since he didn't even know how bad he's going to beat the boy to a certain extent?
That's actually a really good question. In the law, there is a concept that you're charged with, let's say you just agreed to videotape a fist fight, but then it escalates, it gets worse, and somebody gets kicked in the head and there's a concussion. There's a theory of prosecution that you can be charged with that aiding and abetting if you encouraged or motivated by taking the video. So that's basically what we're arguing in this case. We're not saying that he actually participated in the assault, but even if the young men who assaulted him only meant to, hit him, in which case it wouldn't be an adult court. When he was down on the ground, they started kicking him. So that's what led to when you commit an adult crime, you can be charged as an adult under Michigan law at the discretion of the prosecutor. Have I answered your question? All right.
Good morning, and I'm glad we were able to watch the argument today. It's actually a really interesting issue, and I work in family court, so this stuff is near and dear to my heart, so to speak. I want to know why the prosecutor chose this case to take up as an automatic waiver, when I feel like a traditional waiver would have been more appropriate. There would have been all of the circumstances could have been brought in, so I'm really trying to understand. You guys could have had a stronger case, where it wouldn't have been slides or tennis shoes, etc. So why the push on this one, especially if it was the first one ever in Livingston?
Livingston County?
Yeah, and that's a good question too, and a lot of it involves the charging discretion. But I think it was, as I spoke to the justices regarding the severity of the assault and the injury that was inflicted, those were certainly concerns. And the fact that it was videoed and then put out on social media, that exacerbated the crime. So that, because in my opinion, it's like child pornography. Once it's out there forever. And this poor kid who suffered, these injuries in this case, he's always subject to humiliation when someone sees that video. So those were some of the things that went into the charging decision, I'm sure.
What is the difference between a traditional waiver and an automatic waiver?
I'll answer that one.
Sure.
So typically, an automatic waiver can only occur when there are certain kinds of crimes, typically first-degree murder, first-degree criminal sexual conduct, arson, things that are extremely serious. That's what the statute says. If there's a lesser crime or a serious crime, depending on the facts of the case, the prosecutor can use a traditional waiver process. So automatic waiver means just that. The prosecutor has decided they want this case in the circuit court for whatever reason, as Mr. Warden explained. For traditional waiver, the prosecutor has decided it's a felony that this juvenile is charged with, but they also want the court to waive the case to adult court based on the defendant's personal history. So I have another case in Livingston County that's a traditional waiver case where the client was charged with unlawfully driving away a go-kart, not a serious crime, but because of his criminal history, he has been traditionally waived to the circuit court. Does that make sense?
It may be misunderstanding, but I feel like I've heard two different descriptions of the law as far as the use of a dangerous weapon. One where it's the use of a dangerous weapon, and then another where it's the use of and carrying of a dangerous weapon. So does the law make explicitly clear that there has to be the use of the dangerous weapon within the act, and then also, in addition to that, carrying of the weapon as a dangerous weapon, which I would maybe interpret as requiring intent when putting on the shoe, when putting on the clothing. For example, I'm wearing a ring today that's rather thick. If I came here just to wear the ring, but then got in a fight with someone as a juvenile, does the law require not only that I use the ring to punch someone, but that I also put it on today with the intent to use it?
That goes to the heart of the question before the court. And if it makes it clearer, I can read the actual line from the statute, which says, an object that is likely to cause death or bodily injury when used as a weapon, and that is used as a weapon or carried or possessed for use as a weapon. So there has to be intent to use it and carry it as a weapon.
MCL 764.IF states that if the person is armed and dangerous, how can they charge them with that when he was not the one holding the slide or he did not touch the shoes?
Well, the Code of Criminal Procedure, which that statute falls under, also includes the statute involving aiding and abetting. And anyone who incites or motivates or gives encouragement to another person to commit a criminal act is just as liable as they are. And that kind of goes along with what I was saying earlier. If this had just been a fist fight and only punches were thrown, even if the victim suffered a concussion from that, the co-defendant would not have been charged under the automatic waiver statute. So you have to read statutes together so that you don't get absurd results, because the legislature supposedly knows about all of the laws of the state of Michigan, including case law that is issued by the Court of Appeals and the Supreme Court. So all of those things factor in to whether you can charge someone with aiding and abetting.
So you just said the word again. What does aid of meeting mean?
I'm sorry?
Aid of abetting. What does that exactly mean?
Yeah, that's what I was just talking about. Like if you give encouragement, like if you passed out baseball bats to your friends and said, get that guy, and you're not holding a bat yourself, but if they do it, you've actually encouraged them and you've aided them and abetted them by giving the instruments that they used as dangerous weapons. So it's a statute, it's a theory of prosecution, which quite often we use when someone didn't actually commit the crime themselves, but they helped somebody else do it.
Right, so their aiding and abetting can take a lot of different forms. I recently tried a case in Livingston County where the theory of the prosecutor was that my client encouraged or induced the crime that the principal committed by his words or actions. So he didn't necessarily partake. He wasn't even in the same county when this occurred, but because of his encouragement or inducement, the jury could find that he was guilty as an aider and abetter.
Hello. I believe one of the main contentions of the appellant is that the writing of the waiver in question can potentially be detrimental in an unfair way to the defendant. If the defendant receives fewer rights than might even be constitutional. If the court agreed with this finding, what would potentially be the process for rewriting or amending the waiver in question?
Well, one of the things, and I talked about this with Mr. Warden yesterday, there are other procedures for charging young people, juveniles, with adult crimes. One is called a designation trial, where basically an adult crime is charged and tried in the juvenile or family court. And in that procedure, there are the protections I'm seeking for a child who's been charged with such a serious felony. There's also the traditional waiver program where someone could go through a waiver process where the judge determines that they not only probably committed a crime, the probable cause part, but that they also have a criminal history or personal history that mandates them being charged as an adult. So we already have those in place. If this entire automatic waiver statute were to be called into question, it wouldn't really change a whole lot. The prosecutor would just have to go through these other procedures that allow for safeguards and provide safeguards.
Hello, I'm so sorry, I speak loudly. Working in a high school, oftentimes we see when there's an altercation or a fight between students, there are often, I would say almost always, many bystanders standing around, whether or not they had planned to be there when it first happened. But speaking in terms of the bystander effect, you can do a lot of good with that, but if no one steps in and makes a change or tells someone to stop, can you be held accountable for that if you are right there and do nothing to step in? Or are those kids just standing there watching, doing nothing? Are they safe from prosecution eventually, if it were to come to that?
I would say no one is safe under that. I see people charged with crimes for things that are hard to understand all the time, and I think that I have seen school fights too. I went to high school, and there were people cheering on the sidelines, and that alone could be considered encouragement enough to charge under this statute, and that's what the prosecutor did, and that's why I'm concerned about the statute.
You have to remember that the prosecutor is an elected official, so he's running for re-election every 4 years. If he starts charging high school kids for just watching a fight, he's not going to get reelected. In fact, there may even be a recall petition. But what made this case different was the fact that he videotaped it at the request of a co-defendant, and then the co-defendant, he gave the video to him after the assault, and he put it on social media, which everybody saw. So I think you can distinguish those circumstances, and the district court judge, when he bound over, he did. He said he thought that the defendant in this case was in on it, and that he knew it was going to happen. Now, he may have only thought it would be a simple assault, an assault and battery, just punches thrown, but it escalated into something greater.
Could you outline for us the differences in the sentence from a juvenile court to an adult court for the charges?
So if you're convicted as an adult after being automatically waived, as in this case, you would receive an adult sentence, which means you would not be only subject to juvenile court jurisdiction, you could be sentenced to prison, adult prison. So if you're only in the juvenile court, and I say only, but there's still serious repercussions, the court would then determine the appropriate sentence for you. If you're under 18, that might mean incarceration in a juvenile facility, and you could be held until you are 21. It generally doesn't include that. It usually would include some kind of probationary term. For guidance, the co-defendants here got a probationary term in the adult court, but that's a much different kind of probation than juvenile court probation, so it's more serious in every way.
So, if shoes were to be declared as a dangerous weapon, would there be any restrictions put on them? Would anything happen that would affect us as individuals, or is it simply just a label?
Well, it depends on how you use the shoe. If you use the shoe to injure someone, kicking them with it, or even, I think you could injure someone with a shoe in your hand. Justice Bernstein alluded to that, because sometimes you can strike someone with greater force that way. But it depends on the injury. That's the best evidence. In this case, we had the concussion.
I think that's all the time that we have for questions. I need to go back and rewind a second because I skipped over a part of my outline. If I could have each of the attorneys kind of introduce themselves and just say a little bit about what they do in their practice. We'll start with the appellant.
I forgot to introduce myself at the start of my argument, so I'll do it now. I am Christina Dunn, and I'm one of the public defenders in Livingston County. We have a relatively new public defender office, and I love working there. I started out as a public defender in my career. I've always been a criminal defense attorney, and I always wanted to go back. In our state, we are increasing the number of public defender offices throughout the state, and that provides better representation to defendants. So I've been practicing for over 32 years, and I also teach. I've kind of been thrust into this whole juvenile law arena without knowing why, but I'm also teaching a juvenile delinquency course, a 2-credit elective course at Wayne State Law.
And I am William Warden, and I have been an assistant prosecutor since January of 1988. And most of my career, I have been an appellate prosecutor, which means that I do legal research, writing, and oral argument in the lower courts, the district court, circuit court, court of appeals, and the Supreme Court. And obviously, I love my work, or I wouldn't still be doing it at the age of 68.
So following, we're now going to move to a picture-taking session, and then there's going to be a reception. If there are additional questions, if you're at the reception, please feel free to ask the attorneys or the justices who will be out here shortly any additional questions that you have that maybe you were too shy to ask or that we just didn't get to. And with that, if I could have another round of applause for our attorneys here today.